as the sovereign immunity, but I think you don't need to get into that because the contextual difference is so clear.
Well, why should it be less demanding under the spending clause? When the question is whether Congress has abrogated sovereign immunity, the question is whether Congress has done something to itself. When the question is whether Congress has imposed a condition on the state, the question is whether Congress has done something to another sovereign. Why shouldn't the standard be at least as strong when it is doing something to another sovereign, to the employees of another sovereign?
So on that, first of all, Sassamon was as to another sovereign, right? It was as to the state. And I'm not fighting.
I understand that, yes.
I think I'm comfortable with it being the same standard. I mean, but I think we have the clarity. It's drawn from context. And I think one of the things that's very different about this case than this Court's other recent cases in this area is this is not an implied right of action. There's nothing implied here. This is not implied enforcement through Section 1983. This is an express right, an express remedy. It expressly runs against an individual. And as Tanzan said, the distinction from the sovereign context is obvious.
To the extent that prison officials have been doing things that violate REALUPA but wouldn't violate the free exercise clause, who is to blame for that?
The conduct on the ground?
Well, who is to blame for the situation that allows that to happen?
I mean, I think under this Court's decision in Employment Division against Smith, there is some daylight. And the crux of this law, I think, is that Congress wanted to ensure that any state prison that accepted federal funds, this is the heartland of the law, provided greater accommodations, provided pre-Smith protections, and damages were vital to the pre-Smith scheme, as Tanzan made clear.